All right. Well, we're going to start our event now. I'm very delighted to be having a conversation this morning with a longtime colleague and friend, Jonathan Barnett. Is to both celebrate and dig into his new book, The Big Steal, Ideology, Interest, and the Undoing of Intellectual Property. Which is the theme of this event, despite its title, the big steal, how big tech is stealing intellectual property, which is a big part of the book and how that happened. For those who don't know Jonathan as well as I do, he's the Torrey H. Webb Professor of Law at USC Gould School of Law. This is actually his second book. His first book was published several years ago called Innovators, Firms, and Markets, The Organizational Logic of Intellectual Property, published by the Oxford University Press in 2021. Another excellent book. I highly recommend it. And he is, of course, widely published in many academic journals, Harvard Law Review, University of Chicago Law Review, Yale Law Journal. You may have heard of some of these schools. And is widely regarded for his economic and legal and historical analyses of intellectual property, how intellectual property is used by institutions like firms and other types of commercial organizations to both create and commercialize the types of new assets and new technologies and new creative content that really drives our innovation economy. So welcome, Jonathan, to the Hudson Institute.
Thank you.
So for those who don't know me, my name is Adam Mossoff. I am chair of the Forum for Intellectual Property here at the Hudson Institute, and where I am also a senior fellow. I also am a professor of law at Antonin Scalia Law School at George Mason University here in Washington, D.C. So as I mentioned, I don't want to. As I mentioned, we're discussing Jonathan's book. I have my own copy here. You can never have too many copies. You don't want to hear me kind of go on and on and on more about Jonathan's many accolades and publications and whatnot, because we really want to talk about this book here this morning. And so I guess we'll just kick off with kind of an obvious question, which is what motivated you to write this book, especially given your past scholarship and things of that sort. And since this is DC, probably the best thing to do is to situate it within kind of the policy space, within kind of the broader policy debates that we have all been witnessing in the courts and Congress and the agencies with respect to big tech and intellectual property.
Yeah, absolutely. And I'd just like to start off to thank you, Adam, for putting this event together, and Hudson for inviting me here. And I'm excited about being able to do an event right here in DC, because that's why I wrote the book. I want to have an impact on the policy conversation, on IP policy, on innovation policy, in the tech markets, in the content markets. I think we've gone astray. We've built an IP policy over the past 2 decades that is suited for one business model and ecosystem. It's a good business model, but we want the market to have a choice. We want capital to be able to invest in all types of business models in tech and content, because we never know the right one, and competition is going to discover the right mix for us. We've built an innovation system right now over the past 2 decades by degrading our patent system, degrading our copyright system that only works for one business model. And so what I've done in this book, I've tried to take about 15 years worth of academic research. It's a mixture of empirical research, theoretical economic research, traditional legal reasoning. I'm putting that all together here and trying to put it in a package to show how the IP system has changed, why it changed, and why it's changed for the worse. And I have a good news chapter at the end, which is both where we see some glimmers of hope, of improvement in certain parts of the system, and how we can push it towards a more balanced trajectory. So that's why I wrote the book.
Oh, okay. One of your big themes in your book, of course, is this what you call an accidental alliance between big tech, activist organizations, and academia, which might seem to some people who have not been kind of deep in the weeds on these issues, a little odd. These are somewhat strange bedfellows. One normally does not see or hear of companies being closely aligned with academics and the two of them also being closely aligned with activists who are advocating on behalf of various positions to weaken IP. So how did this come about, and why do you think this academic alliance is important?
Yeah, so it's what I call in the book, exactly as you put it that way, an accidental alliance. There's a confluence starting around the mid-2000s that continues today with an overwhelming conformity of opinion in the academic and policy conversation space that we're generally better off reducing the strength and the force of IP rights, that IP rights automatically confer market power, they entrench incumbents, they raise entry barriers. That's the narrative that's coming from much, not all of legal academia, parts of the economics profession, and that links right up with the advocacy and the lobbying activities that I document in the book through data on amicus briefs that are filed by large tech platforms, by trade associations with which they're associated, with advocacy organizations with which they're associated. It all converges on the same policy outcome. There's business interests among the large tech platforms and perfectly rational business interests to reduce the strength of IP protections. That links up with a narrative. In some cases, I would call it an ideology, in the extent that it's not particularly open to cost-benefit analysis, that is deeply skeptical of IP rights and deeply skeptical in some cases of property rights in general. This produces a powerful narrative, I think, for DC policymakers, especially policymakers who don't have a particular settled view about IP rights. And it has pushed the trajectory of IP rights where policymakers have a choice. The default position today is to weaken patents or weaken copyright.
That's interesting. I mean, you said there's skepticism about intellectual property, but it's intellectual property, and and you mentioned that we have weakened intellectual property. So this has happened over the past decade or so. Can you give some examples or talk about it? In what way has policy shifted? So
yeah, let me give you two examples, one from the text space and one from the content space, because one of the contributions in this book is to show this uniform weakening of IP rights, whether you look at patents in tech, whether you look at copyright and content, and that's not fully appreciated for understandable reasons, both in industry, academia, policy. People tend to be a patent tech person or a content copyright person. So one of the insights of the book is to show this sweeping reset of intellectual property rights wherever you look in the innovation ecosystem. And wherever you look, what you see is intellectual property rights starting to lose their property-like aspect. What's the fundamental characteristic of property right? It is the ability to exclude those who are using the asset without your consent, without negotiation. Right? That's how we think of property rights in a physical world. It's the same exact thing in the virtual world, in intangible goods markets. So let's take an example from on the patent side. eBay decision 2006 gets rid of the long-standing historical presumption that if the patent owner defends the presumption of validity and demonstrates infringement, they are almost always going to be entitled to an injunction. That makes perfect sense. If a patent is a property right, the injunction should issue. eBay removes that presumption, and it has been interpreted expansively to the lower court so that increasing categories of patent owners no longer have any reasonable expectation of ever being able to secure an injunction. That's not a property right anymore. That's starting to look like a compulsory license. Now let's move over to the content side. In the early 2010s, Google undertook a project with partner libraries to form what's known today as the Google Books Project. Microsoft and Yahoo were undertaking similar projects at that time. One of the reasons that the Google Books Project was more successful is that Yahoo and Microsoft only digitized books that were out of copyright or for which they got a license. Google copied everything. That is probably the single largest case of infringement of copyright in US history. They then go to court, and it's a gamble. What is the strategy here? It's to use other people's stuff, induce a litigation, and then hope you can change the precedent so that the property right is weakened and you can use that content for a low price or preferably nothing. And that gamble paid off in the Google books and the Antitrust litigations, where we get an expansive understanding of the fair use exemption. And Google has just digitized millions of books without consent, and it has paid absolutely nothing for that. That's a compulsory license at a zero royalty rate. So whether you look on the tech side, the content side, IP starts to lose its property-like features.
So it's interesting you have two examples one from the creative industries, the content side, Google Books, the other from patent law, eBay. These are typically siloed from each other. So typically they're not talked about by the same people. I mean, typically people are copyright experts or patent law experts.
Yeah.
And yet you integrate them and interweave them in your book. How do you see them as interconnected here? And how did this come about, and why is this important?
Right. Yeah. Let me give you an example right here. Okay. Here we have one of the really interesting things in the digital ecosystem, right? And what you're observing in the book, right? You're observing the change in the property rights infrastructure in response to technological changes, but also in response to a political strategy by different stakeholders to influence that property rights infrastructure. So in this device that we all have, right, we have the convergence of tech and content, right? And inside, let's just focus on this, inside the smartphone-based ecosystem, one of your key stakeholders, it's situated right around the middle of the supply chain, are the platform tech companies. Now, the platform tech companies invest, most of them, not all, but most of them invest significant amounts in R&D. But their model for monetizing R&D, either R&D that they've developed themselves or content or tech assets that are produced by others and are integrated into their system, it's an aggregator model. It's an integrator model. So let me give you an example. If you're YouTube, content is an input. The more content you have, the better content you have on the platform, the more users you have, the more ad sales that you're going to be able to make. Just like any other business, perfectly rational, perfectly legitimate, YouTube wants to reduce the cost it pays for those inputs. But how do businesses usually do that? They do that by negotiating with the supplier for the lowest price possible. The key insight of this book, the heart of this book, is that what the platforms undertook to do here successfully is to reset the price of all IP assets throughout the ecosystem by changing the rules of the game. And the most fundamental rules of the game, they're changing, and they have changed, the property rights infrastructure of the digital ecosystem. As you make property rights weaker, whether it's property rights over content, whether it's property rights over tech, bargaining leverage shifts from the innovator, it shifts from the content creator over to the aggregator, over to the implementer. That's the wealth shift in the book. And that's what distorts the innovation ecosystem. We want to have an IP policy that works for all stakeholders. The platforms play a valuable role, a vital role in bringing economies of scale and seeding the market and deploying the technologies rapidly and efficiently. But we have an inefficient market at the top of the supply chain because we no longer have a property rights infrastructure that can support the most efficient possible markets to price out the content that's going into YouTube, to price out the wireless technologies that are the brains behind the phone, which are not developed for the most part by the platforms.
So the innovators are at the high end of the supply chain, or the upstream of the supply chain, that are providing the innovation, the technology to the platforms. Now, this is really interesting because most people think of the companies you're talking about here, I assume Google and Facebook and YouTube, it's now owned by Google. A lot of them think of these are the great innovative companies, and they talk about how innovative they are and how much they invest in new technologies and AI and things of this sort. And yet you're also arguing that that they have been pushing to devalue IP rights. So how do you square that? Because it seems to be in conflict with each other. Like they're investing a lot in R&D,
Sure.
developing new technology. You said yourself that they're valuable. I mean, that's something, for instance, that the pharmaceutical companies do. They invest a lot in R&D and produce new innovations.
Yeah.
Healthcare, something you talk about as well in your book.
Yeah.
So how is it then that there is that you get this conflict again? You mentioned it, but maybe we can circle back to it of how do you square these companies that are creating new technology or doing innovative things, investing in R&D, and yet are interested in devaluing intellectual property, devaluing typically the products and the protections that people see in R&D?
Yeah, sure. So the platform companies, just like the even broader class of vertically integrated companies, platform company is essentially a systems integrated company. It doesn't require, for the most part, patents in order to monetize the technology because it's integrated inside a bundled product and services ecosystem that is difficult for most other companies to replicate. Okay? But let's move up the supply chain now. So if you're a chip design company and you don't actually produce the chips, or you're developing wireless technologies that are making the smartphone device work. You're not the customer-facing company, right? And you have a licensing-based business model. That licensing-based business model does require IP rights because you need to take that technology and stick it inside what I call a property envelope. What does that property envelope do? It starts to make a market in that IP asset. Right? We often hear from IP skeptical commentators that IP is a tax on the market. But that's not true at all with licensing. Because what does licensing do? It allows the R&D firm, what I call the idea factory at the top of the supply chain, once that idea is inside the property envelope, it can be distributed throughout the market. Any device producer can use that technology and enter the market. Contrast that with a market in which IP rights are weak. Innovation may continue, but it's going to take place within silos, within walled gardens. That's exactly in the previous book that Adam mentioned, which looked at economic history prior to throughout the 20th century. What I found there is that periods of US patent history where patents were weak, innovation took place inside large integrated firms, AT&T, RCA, Xerox of the day. As we continue weakening patent rights, we're going to continue to distort our innovation ecosystem so that innovation has to take place within large systems integrated companies, as opposed to a world in which businesses are free to choose from a variety of business models. Sometimes integration is the way to go. But sometimes licensing is the way to go, and sometimes there may be yet other business models. Strong IP rights allows the market to make that choice rather than making that choice for the market.
So you've mentioned that these arguments, these IP skeptical arguments through this accidental alliance have been very successful in the courts and Congress and in agencies over the past 10 years. You've already given two examples, at least in the courts, right? The Google books and eBay.
Yeah.
Can you give some other examples that you talk about in the book that with Congress and in the agencies where the arguments that intellectual property needs to be weakened or eliminated has resonated with them and has resulted in actions that have devalued the IP system? Sure.
Let's take as a mini case study the America Invents Act enacted 2011 when it went into effect in 2012. Now, if you see leading up to the act, you see extensive lobbying expenditures by large technology platforms lobbying for the act. But here's where the accidental alliance comes into play. Coming in from that, from academia, you have a number of widely publicized books. You have preliminary empirical findings. You have theoretical assertions, which are all talking about what I call in the book a parade of patent horribles. You have patent thickets. You have patent trolls. You have a patent explosion. And so you have a series of provocative slogans, which are often based on preliminary findings, that later, when those are subjected to empirical scrutiny, turn out to lack foundation or turn out to be more complex. Let's just zero in on one particular case. In 2001, there was an article published that claimed that 97% of applications at the USPTO were approved. This supported the so-called junk patent thesis. A year later, the same authors corrected that, brought that down to 85%. There have been subsequent empirical studies showing, and they all showing that the range is somewhere closer to 60 to 75% approval rate. And now the junk patent story doesn't seem to be exactly accurate, would probably be an understatement. But at the time the act is enacted, that's what's in the public mind. And we get the Patent Trial and Appeals Board. And today, the most frequent petitioners, challengers of patents at the Patent Trial and Appeal Board, are the same companies that lobbied for it in the America Invents Act. And so that's where you get this confluence of conjectural assertions, preliminary findings coming in from academia, lobbying from business interests, again, who have a rational interest in weakening the patent system. And that produces actual policy results. So that today, if you are a small firm patent owner, you're going to have to defend your patent in district court. You're going to have to defend your patent in the PTAB as well. And we produced, again, a patent system that suits the business model of large integrated corporations. It does not suit the business model of what I call the idea factory, of the licensor, of the small firm inventor.
Now, a lot of people think of the social media companies as idea factories, and Steve Jobs created the iPhone. That he created iTunes. So again, is your argument that their ideas are at an intermediate level and they're just trying to devalue the more fundamental innovation and ideas that are being produced upstream, that are being provided to them in the supply chain?
Yeah, a systems integrated company
Yes.
has far fewer concerns about knowledge leakage to competitors because everything is integrated within the same system. Let me give you an example. Google search, right? The PageRank algorithm, that was patented when they were a startup coming into the market. But Google doesn't patent the new and improved and constantly improving versions of the algorithm, which is all innovation. Again, let me emphasize, the platforms are innovative companies. They are delivering innovations, but they do not require a patent right because it's all being monetized in-house. They do not need to go out into the market and license it to others, and so they don't face that same knowledge leakage problem. At the same time, in cases in which they are using content or tech from others, right? So if you are a branded device producer and you're not historically been the one developing the brains behind the device, the wireless communications behind the device, you will be better off with a weaker patent system where bargaining leverage shifts over to the implementer, shifts away from the innovator, and you'll see royalty rates coming down on those technologies. Again, it's the same thing as I described on YouTube. The input costs are being reduced by weakening the property rights system, weakening the leverage on the part of the innovator, and you get lower rates on the device, higher profit margins for the device producer.
So Apple is another closed integrated systems. They, while innovative with respect to the iPhone, still rely on other technologies, as you mentioned, like the telecommunications technology you talk about in the book, what we call 3G, 4G, 5G. The G is just generation. That's invented by other companies like Qualcomm and InterDigital, Nokia. So they're licensing it to Apple, and then Apple's trying to devalue and lower the cost of their input. They see that innovation as an input cost, and they just view this as a commercial strategy. How do we lower our costs? How do we, in our production supply chain, that supply chain includes innovation.
Yeah.
So we
Yeah.
so we weaken or eliminate the property rights that give us the better leverage. Is that kind of a good?
Exactly, and let's just focus and zero in a little bit more on that industry.
Okay.
In the wireless industry, I had mentioned that in light of the influence of the eBay decision, there are increasing categories of patent owners that effectively have very little prospect of ever being able to secure an injunction, even after showing infringement. In the wireless industry, the chip design suppliers who sit at the top of the industry, they are supplying the brains for making the device work. They have very little prospect of ever seeking an injunction. And just to appreciate why does that shift leverage in a significant manner away from the innovator over to the implementer? Very simple reason. Because it means that the innovator can never deny access to the implementer. The best case that they can get at the end of the day is a reasonable royalty reward equal to the amount that would have been paid anyway if they had ever entered into a licensed transaction at the start and avoided all the litigation. That's why in an interview that appeared in an Economist article, former head of patent licensing at Apple, stated that the efficient strategy for Apple, even a fiduciary obligation to maximize shareholder value for Apple shareholders, is to decline a license and litigate it through to a royalty rate determination, which again makes perfect sense if you are living in a world where a patent has lost one of the key characteristics of a property right, which is the ability to exclude. And that's where the IP equals monopoly, what I call the information wants to be free narrative, where it has things backwards, right? Because our natural intuition, our understandable intuition, we reduce IP rights, we weaken them, we're going to open up the market, and we're going to increase competition. But in the example I just showed you, it's exactly the opposite. If we strengthen patent rights, we allow the chip design firm to come into the market and to license that technology instead of having to produce the chip and have an integrated structure all the way into the market.
So it's interesting you're talking about the success of these companies like Google and Apple and others that have made incredible inroads in the courts and in Congress and with agencies. I haven't mentioned agencies. Maybe we should talk about that a little bit. The primary one, I think, being antitrust, which you talk in the book about, and the antitrust actions that have occurred against patent owners. But in recent years, this may again sound a little odd to people because most of the news we see about antitrust is directed against these companies, against Apple, against Google, against the social media platforms more generally, and not just in antitrust. We hear them lots of complaints about they're stealing data, they're violating privacy rights, they're trafficking in child pornography, and things of this sort. And many of these criticisms share bipartisan support. You hear them from both sides of the aisle, and the R's and the D's, and yet they're being very successful with their narratives about intellectual property, as you explain in the book. So again, there seems to be a disconnect here. How do you account for that, or how do you explain that?
Yeah, we haven't been able to, the message that IP rights not only support innovation, but they not only make markets more innovative, they can make markets more competitive. That's a message that I think needs to be understood more deeply, and that when we reduce IP rights, we make it harder for some of the most innovative firms to enter the industry, and we entrench incumbents in doing so by erecting entry barriers. Let me give you another example to illustrate this. Up until roughly the late 90s, early 2000s, if you looked at the semiconductor industry, the companies all looked mostly like Intel today. They were all vertically integrated companies doing everything from A to Z. Patenting in the industry at the time was not a priority, and that makes sense given what I've said, because the information is mostly all traveling in-house. It's monetized within that integrated structure. Starting in the late 90s, early 2000s, you see patent activity in the semiconductor classes increasing. If you're an IP skeptic or were an IP skeptic at the time, the prediction would be we're going to have patent thickets, we're going to have a tax on consumers, innovation is going to slow down, and the device prices are going to increase. Exactly the opposite happened. The increase in patenting in the semiconductor industry completely changed the market structure in a way that made it more competitive. How did it do that? Because it enabled the entry of a new type of entity into the market, a chip design firm that only does chip design, known as a fabless firm. It has no fab. It has no production facility. How does it monetize its innovation? It enters into a contractual relationship with another new entity, a foundry, the most famous being TSMC. What does IP rights have anything to do with that? Because when information is traveling from the chip design company over to the foundry, it's available to be seized by a sophisticated party. Again, we stick it inside the property envelope, we make that transaction happen, we have a new supply chain structure, the market discovers a more efficient way to deliver chips to the devices and to the consumers, potentially even making those devices cheaper. But most importantly, what has it just done? The IP system has just dried out the moat around companies like Intel, because the IP system reduced entry costs into the market by literally billions of dollars. That's the cost of producing a fab. That's the insight that we're missing today in the antitrust IP interface. We often think of antitrust and IP being at loggerheads. It's a natural tension is the common assumption. But at least in certain industries, and I could give you some more examples, but at least in the example I just gave you, semiconductor industry, it's hard to think of an industry that's more important economically, more important geopolitically. Increased use of the patent system made the market more innovative and made the market more competitive.
So this is very interesting because, again, this kind of runs counterintuitive to a lot of people's assumptions. They hear patents are monopolies, the right to exclude, it's a barrier to people. You could extend that same argument to other areas. Copyright is also a barrier to entry. It's the right to exclude. This stifles innovation. This reduces the ability to compete. But you're arguing that that strong protection of reliable and effective patent and copyrights, right, actually promotes competition and disaggregates the market and breaks down these integrated companies, these large behemoths and monopolies that we are now complaining about through the antitrust laws.
Strong IP rights are a leveler. They level the playing field. Remember, in order to derive value from an innovation, you've got to commercialize it. You've got to test it. You've got to produce it. Those are the capital-intensive parts of the timeline, of the development timeline. When you have IP rights, you allow the small firm to enter. You allow the idea factory to enter, who can't compete with the larger firm on all of those capital-intensive, labor-intensive functions. But they can out-innovate. And when you have the patent, you shift bargaining power back towards the innovator. That makes sense economically. If we go back historically, it also makes sense in terms of the vision behind the IP clause from which all this derives, right? That's one of a uniquely American tradition about the U.S. IP system. It's about the capital I inventor and the capital A author. It's about giving them a property right that gives them bargaining leverage vis-a-vis the existing players. And that's why you get the counterintuitive conclusion that making IP rights stronger actually lowers entry barriers and it enables entry. And if anyone is skeptical on this point, I would just point them to the fact in the book that is one of the most well-documented facts in the book. If it is really the case that IP rights entrench incumbents and block entry, then why in the world are some of the largest tech companies in the world lobbying against them? Perhaps we should think more carefully that perhaps the counterintuitive insight is what's going on here, that it's weaker patent rights entrench integrated firms, making them stronger is what enables maverick standard, innovator standard, enables the disruptor standard. We want the disruptors. We want creative destruction, and we want people to be able to challenge the incumbents. Not in all industries, but in many industries, IP rights are a critical tool to make that happen.
Before we kind of maybe shift to a little international context, I don't know if anyone in the audience has a question. We covered a lot of ground: antitrust, IP, history. Yes. Just state your name and maybe affiliation. Someone's coming with Talia's coming with a mic, and he has a question here. So just state your name, affiliation, and then shoot your question.
Well, my name is Sam. I'm an intern here at Hudson, and you seem to be posing that these idea factories and the integrated firms are kind of at two opposite spectrums of this IP system, and that empowering one disadvantages the other. Is there a point that you can see being reached that would bring them into more of a cooperative space?
Sure. Well, my answer to that is that the platforms themselves, the ecosystem in general, including the platforms, are going to be better off under a stronger IP system. Why? Because if our idea factories are the ones fueling the innovation ecosystem, if the high-value content providers are fueling the content ecosystem, right? The platforms are better off today with weaker patent rights because then they get everything in the pipeline for free at our low cost. But you need to maintain an incentive structure so that it makes sense for capital to continue funding new innovations, new high-value content production. So your content pipeline on the content side is going to start to run dry. And in fact, there's evidence that the market actually recognizes that. If you look at the digital content markets, some of those markets have actually recovered. They have discovered viable business models in a digital ecosystem, even when there haven't yet been significant changes to the copyright case law. So things like music streaming, things like Netflix, things like ebooks. But what do these things all have in common? All of these services, all of these markets have developed technological equivalents to property rights, which have allowed markets to form, which have allowed subscription models to work. Ad-based models don't work in content markets for the most part. Now we get the revenue flow going. We got the revenue flow coming up from the subscribers, and we got the revenue flow coming up to the content producers. Now the ecosystem is healthy again. Now we have an innovation ecosystem that works better for all stakeholders, the content producers and the platforms. Again, the platforms play a vital role. We need those scale efficiencies to distribute that tech, distribute the content out efficiently. But just as it's uncontroversial to say that you need property rights for physical goods markets to form, it should be uncontroversial that you're not going to get capital investing in pharma, investing in high-value content, investing in wireless innovation, investing in deep tech, unless you got a property rights infrastructure. And that's what we need to restore.
Clearly, you're clearly not from DC because you just said it's uncontroversial that you need property rights for markets to form and for goods to be produced. There are a lot of people here in DC who don't necessarily believe that. So, but welcome to the DC policy world. So in the book, you don't just talk about kind of what's occurred in the United States domestically, you know, in the innovation markets and technology and in the creative industries. You also expand out the scope of your focus and talk about what's going on in China. And you actually illustrate and talk a little bit about what's going on there with the regulators and courts and how they also are adopting similar views of weak IP rights, especially in tech markets. And actually are reflecting back or mirroring back to the US a lot of the rhetoric and concepts that have been deployed, like patent thickets and hold up and things of that sort. So why is that happening? Because we often hear about China being very innovative and growing their innovation economy and protecting intellectual property rights too. So why is this happening?
Yeah, sure. So again, we're in the wireless technology space. We're in the mobile communications devices. I think it's well known the vast majority of these devices during exactly this period, this 20-year period, production shifts massively over to China. China is equivalent in the wireless technology supply chain it occupies sort of a similar space as the platforms. It's right there in the middle. It's a device producer. Okay? But again, historically, it's not the innovator of the 3G, the 4G LTE, the 5G technologies that are making that work. Those are developed literally by a handful of companies based in the US and the EU. Now, I'd mentioned before that if you're a platform company and content or tech is an input, just like any business, we can look on the street here, a bookstore, we have a steel manufacturer, whatever business you give me, every business wants to reduce its input costs, right? And the grand strategy in this book, the heart of the book, right, is changing the rules of the game, the property rights infrastructure, so that bargaining leverage shifts from innovators to implementers, and you're going to reduce the cost of those inputs for the platforms, okay? Now let's just take that same logic, and we're going to move it up from a level of a company, a level of an industry type, of entity type, and we move it up to the level of an entire country. Okay, and so if you are located at the midpoint on the wireless tech supply chain, you're an implementer. You're playing a valuable role as an implementer. There's a reason that production is taking place in China. It's the cheapest, most efficient place for companies to locate production there. Okay? But if you're in a political system where you have party-state fusion, where you don't have division of powers, right? You can use your antitrust system, you can use your patent courts to pursue mercantilist objectives, geopolitical objectives, in a manner that systematically favors local device producer industry over foreign innovators. And as I talk about in the book, and I've shown in more detail elsewhere, you can see that both through policy statements at the highest levels of leadership in China, and then you see that implemented in draft guidelines by competition agencies, by enforcement actions by competition agencies, in one famous case that specifically resets downward the royalty rate through patent infringement litigation, where royalty rates are set at rates that are typically significantly below rates in the market or below rates in other states. So it's the same logic that's being used domestically in the US, being used in China, apparently for mercantilist purposes. And as you mentioned, the same concepts, the same rhetoric that's developed by US and EU antitrust agencies in the wireless licensing space, you see that adopted by Chinese competition regulators and courts.
So you mentioned that this is part of a mercantilist policy. So this is part and parcel of their kind of the geopolitical strategy to be a competitor with the United States. I mean, it's no secret China is challenging us both economically and even militaristically and building up their army. So how does this matter for U.S. global competitiveness more generally? What we see this development occurring.
Yeah, there's a chapter in the book where most of the book is about let's have the most efficient innovation ecosystem for the U.S. But in parts of the book I show that in some cases where you're taking innovation policy in a place that's not good domestically for the US, if we just look at innovation, you're also doing something that's not good for US geopolitical leadership, right? So if you look at a data point, for example, such as licensing surplus and deficits, right? The difference between how much a company pays to license in technology and how much it receives for licensing in technology, right? Lots of talk right now about trade deficits. Not a lot of talk that the US has a massive IP surplus, right? If you have an IP surplus, that means one of your crown jewel assets are your IP rights. So when we adopt an innovation policy that weakens IP rights and suits one particular business model, the platform-based business model, we're doing something that doesn't work domestically for the US innovation ecosystem, but we're doing something that also doesn't make sense for US geopolitical leadership as well, right? The US is a net innovator, and so geopolitically, it would make sense for the US to strengthen IP rights, not to weaken them.
Because the royalty flows are all coming back to the United States and to the EU. In fact, we published a policy brief on this last year here at the Hudson Institute, actually identifying that the global royalty flow rates in the mobile industry all flow to the United States and to Europe from Asia. And this is why and so you said that at a kind of a countrywide level, at a national level, this is why they're trying to depress this, because it benefits their producers, their manufacturers, their citizens.
Yeah, one thing I would add to that, building on the last comment, just as when we have a stable property rights structure, in the medium to long term, it works better for all stakeholders, because then you have the incentive and the funding structures to support new innovation. Right? One of the visions behind the TRIPS agreement, which is to have a firm IP baseline throughout the world, which the US had pushed forward on a bipartisan basis without exception until the last administration, one particular action by the last administration. Right? That's good ultimately for the whole global innovation ecosystem. The story that I told you about the semiconductor supply chain breaking apart, that's also a story about spreading the wealth globally. Right? Because when you have a secure IP system globally, now you allow companies to locate each segment of the supply chain in the country that can do that the best. You create a global competition. In the medium to long term, it works better for all countries, just as domestically, every stakeholder in the innovation ecosystem will be better off with a stable property rights infrastructure.
So just like intellectual property rights are a leveler, domestically in the United States, they're a leveler and allow everyone to interact and compete equally, even internationally.
Absolutely, yeah. Not in this book, but in other work, I've shown how other countries, particularly countries in East Asia, have used the patent system to move up the ladder of economic development, to move up into the innovation levels of the tech supply chain. They've done that through IP rights. They've done that through being idea factories where they can license and enter into transactions through the safety of the property rights system.
Yeah. So I don't know if anyone has any questions. Speak now, because I have lots of questions to ask him from his book. So, so let's shift a little bit. In recent news, there was a significant decision recently in the AI context. You do talk. We've been focusing a lot on patent law, but you talk also equally as much about the importance of the creative industries and copyright and the protection of intellectual property rights in creative content. And today there's a lot of focus on AI. And there was a recent decision, as I just referenced, in the AI context. Now, what a lot of people hear is, creators of AI, like Sam Altman at OpenAI, go around saying, well, no, we have to do this, without copyright. That we have this is fair use. Yeah. This is you can't have copyright here. Copyright is incompatible with the development of these new technologies. And we have to be able to use copyrighted works, that it's, quote, fair use, as I just mentioned. Now, I mean, based upon what you kind of talk about in your book, is there, how do you view those arguments?
Yeah, this is a total replay of where we were back with Napster and back with YouTube. It's the same arguments again, where you have the arguments coming from the tech platforms that if you enforce the property right, in this case copyright, rigorously, you're not going to allow this new technology to grow. And then we have, of course, the familiar arguments from the content owners that there'd be no way to compensate the originators in the market, and there's no viable business model there. I think it would be helpful if we could learn from 20 years of history, right? And what do we see in the digital content markets? To go back to that previous question and the response I gave, we see that digital content markets work best when we have secure property rights through the combination of contract, copyright, and technology, right? If platforms are able to track at a micro level every micro usage on the internet, it stands to reason that it is possible to come up with technologies in order to track usage of content, to develop payment models that can both allow the AI model and apps to grow, which is important, right? And to do so efficiently, and to do so at low transaction costs, but to do so in a way that preserves revenue flows to the originators that keep fueling the pipeline. And going back to my previous answer, we want to maintain those incentives so that the pipeline continues to have new content. And there's something a little different happening here. Both the decision you reference rejects the fair use defense. And that's showing the influence of an important decision in 2023 by the US Supreme Court in the estate of Andy Warhol case, where the court cut back on the fair use exemption, pushing back against the overwhelming trajectory in the lower court's case law, which has been expanding the fair use exemption for at least a decade or more. And you see the first influence of that, I think, here in the lower courts. You see it also the influence in the fact that although some AI tech leaders have made comments along the lines you've said, we also see some of the major AI model developers entering into licensing transactions. What does that suggest? It suggests that there's some uncertainty about the fair use exemption being applicable in the AI ecosystem or parts of it. And what is that doing? It's shifting bargaining leverage back over to the originator now. It's starting to induce licensing transactions. We see this over and over in US innovation history. We constantly see the argument that if you proliferate IP rights, you're going to create thickets, you're going to bring the market to a screeching halt. But then when you actually observe what happens, markets are amazingly adept at coming up with licensing structures, bilateral, cross-licensing, collective licensing structures to remove these blockages. In the content markets specifically, in the music markets in particular, these have been developed. There's no reason to believe that if we have a simple and clean property rights baseline for content in the AI ecosystem, the market can then build around that certainty, and it can build out licensing structures that make sense for everyone in the ecosystem, make sense for the AI model developers to keep those transaction costs low, and make sense for the content originators to preserve funding streams so that we get new content coming into the system.
So, so in your book, you talk about this the accidental alliance and this very concerted strategic effort at all levels of government, courts, Congress, agencies, and both with respect to copyright and patent law. It paints a very bleak picture, but now here's some good decisions. You just mentioned a good decision from the Supreme Court in the Warhol case, cutting back on the fair use exemption. I don't know of any good decisions yet in patent law context, but maybe they're coming. Where is this coming from then? Why are they in the copyright context? So the recent decision by Judge Bevis in the Thomson Reuters versus Ross Intelligence, you mentioned where the judge rejected the fair use exemption, the use of copyrighted works. Where is that in Warhol? Where is that coming from now then? What explains the pushback?
Yeah. Well, to be fair, we have seen during this period, as property rights have declined, that when the Supreme Court gets a copyright case, they do tend to show a far greater understanding of the interests of content originators than they do for tech inventors on the patent side. And I think we see a return to that tradition I had mentioned that I think characterizes historically the US IP system, that the IP right, one of the functions of the IP right is to empower the individual author and the individual inventor. And while it may be too early to say exactly where we're headed, I think we see a recognition of that. It's embodied in the Andy Warhol case, right? That's a perfect case. You have an individual artist, a photographer, going up against a well-resourced defendant, an estate of a famous artist, and she wins in that litigation. That's a great example of my point I made before, how the property right, it levels the playing field. It doesn't stop the market in its tracks, right? It enables a market to form. It enables a licensing market to form. Property rights enable those markets to form, and they actually will ultimately reduce litigation and reduce disputes, because instead of litigating over IP rights, instead we're transacting over those rights.
Okay. So I mean, as we're coming towards the end of our discussion, talking about some good things, maybe throw out to you kind of a final question, which is, you don't, while painting and discussing and detailing at great length and in really excellent way, these kind of the big steal, and how it has come about in the past 20 years or so. You do end on some policy prescriptions of what maybe we can do now. It sounds like the courts are doing some of it already, but maybe summarize for the audience and then summarize on the good side. So what do you think were the biggest policy errors that were committed in the past 20 years? And then what are the best ways that we can correct those policy errors going forward? Is it found in the courts? Is it Congress? Is it a mixture of them?
Yeah.
Something that the new administration can do?
So I'm going to give you 3 answers. Okay. The first one is going to be my umbrella answer. What I hope I can persuade some policymakers through the book is a renewed appreciation of the importance of IP rights to a healthy innovation ecosystem that works for all stakeholders. That IP rights, they don't shut down markets, they don't tax consumers, the opposite. They enable entry. They enable entry by the individual innovator, they enable entry by authors by allowing them to monetize innovation outside the walled gardens, outside the silos. Based on that re-recognition of why IP rights are important for a healthy innovation ecosystem, why they're important for geopolitical leadership, on the patent side, the single greatest error, which is where we find no precedent for it in US case law. Right? We're also an outlier today internationally, the eBay decision, that the injunction does not almost automatically follow once you show that the patent is valid and it's been infringed. That needs to be restored. That's a simple, clean correction, and healthier, more diverse IP markets can build upon that. I think the corrections on the copyright side, we're starting to see that, as I mentioned with the Warhol decision, cutting back on this unusually expansive understanding of fair use, which people have gotten used to. But again, that's also a historical aberration from the narrow uses for which fair use was understood really as late as the mid-2000s, I show in the book. And so I think continuing to push the case law toward a more measured application of fair use would make sense. And also, as I discuss in the book, the Section 512C safe harbor under the DMCA, I argue in the book, has been interpreted by the courts in a way that it's very difficult to reconcile either with the plain language of the statute and certainly with the legislative history of the statute. The DMCA was supposed to be a balance between tech and content. It was not designed, as you see some judges saying explicitly today, it was not designed to push 99% of the enforcement burden on the content owners. It was designed, arguably, at least to split that burden. And I think it would be helpful if courts could revisit the statute and bring some more balance back to the way that safe harbor is applied.
So that addresses kind of the courts and Congress. Is there anything the new administration could potentially do in righting the ship and getting us back on?
I think that takes us to the kind of the umbrella point here,
yes.
Right? An overarching statement that anywhere you look, right? The book is about a policy, a reset, evaluation downgrade of property rights throughout the innovation ecosystem. Well, the fix to that is evaluation reset upward, right? To restore these simple property rights. It's simple common sense in physical goods markets, right? The same thing applies, the same logic applies in intangible goods markets. When you have property rights in play, you allow markets to form. And I see we just have 3 minutes. To illustrate this point, I'm going to end with a story, and this will be a good story for someone from Southern California. Okay. So back in 1996, Marvel Comics was on the verge of bankruptcy. And why was that? Very simple reason. Comics weren't cool anymore. So the management at Marvel had a long shot strategy to save the company. They decided to license out some of their characters to major production studios. Maybe people will watch. Maybe they're not cool in the book, but they're going to be cool on the big screen. In fact, these were mega hits, 2 mega hits. And then Marvel said, wait, we can take this one step further. We don't need to license it out to them. We can make our own studio, and then we can keep all the revenue for ourselves. One problem. They only needed $500 million to set that up. Merrill Lynch, still this is going back. Merrill Lynch said, yeah, we're happy to lend that to you. What's going to be the collateral? Well, the Marvel manager's house is not quite rich enough in order to support that. What was the collateral? The entire copyright portfolio of the Marvel Corporation. IP served as the collateral. It enabled capital to flow to that asset. You get hit after hit. That's 1996. 2009, they're sold to Disney for an excess of $4 billion. Was IP a tax on the market there? No, the opposite. IP unlocked tremendous value there that could not have been unlocked in any other way. Did IP block entry into the market? No. They enabled the entry of a new major motion picture studio into the market. That's the magic of IP rights. That's the magic of property rights. That's what we've forgotten. The fix is actually quite simple. We need to just simply go back to simple property rights rules in patent, in copyright. The market does all of the complex stuff on top of that.
Awesome. Well, I think we have a new rallying cry: copyright assemble. Well, thank you, Jonathan. Again, here my copy, so you can see it here as well. The Big Steal. It's far more far-ranging than what we were even able to address in our discussion here. Lots of incredible details in the creative industries and the innovation industries with patent and copyright, really showing not just the importance of these rights as facilitators of innovation and commercial development, but also what happens when you degrade them, as we have been seeing today, and how this has come about. So thank you for all this incredible research and for producing this book. And let's hope that your policy prescriptions gain traction here in DC. So,
Thank you.
Thanks,
Thank you.
Jonathan.
And thank you.
Thank you for coming.